the slides, and a feedback form sent to you afterwards. We'd really appreciate it if you send this in, because if you don't complete it, we won't get a good idea of how we can improve and make things better for you in the future. To avoid any distractions during the webinar, please can you mute your microphone and turn off your video. But obviously do turn them back on at the end if you want to chat to any of our speakers directly. Throughout the webinar, we encourage you to submit your questions in the chat box, and we're going to leave 10 minutes at the end of the session to address them. Over to you, Mark.
Thank you very much, Tania, and hello, everyone. I'm just waiting for our slide deck to load. You should all see that now. So as you may expect by the title of today's webinar, we are looking to speak to you, update you, give you some advice on Brexit. In particular, what Brexit means for European Union trademarks and designs. Now, as Tania said, my name is Mark Caddle and I'm a partner in our London office in our trademark group. So today we will be primarily focusing on trademarks and designs. And the reason for that is that European patents are, by and large, unaffected by Brexit. So there's no real update for us to provide on that, and today's session will be focused on trademarks and designs, both in the European Union and in the UK. So the aims of today's session are really threefold. One is to give you some insight on what you should be thinking about now to ensure that your IP in Europe is adequately protected in a post-Brexit world, and to flag to you anything that you need to be aware of, any deadlines, any actions that you'll be required to take this year or beyond to ensure that you're getting the best from the EU IP system. And also we are going to share with you some practical tips on the UK and EU trademark and design registration systems so that you are well prepared for advising your clients or your internal stakeholders on how to interact with the EU IP landscape. So first of all, I'm going to sort of cast our memories back to last year before Brexit happened and just recap on the timeline that applied. And this is quite important to some of the deadlines that apply now and some of the actions that have taken place since the UK left the European Union. So back in 2016, a long time ago now, the United Kingdom held a referendum and the decision was taken for the United Kingdom to leave the European Union. And as of the 31st of January 2020, the UK officially left the European Union, but remained in what was called the transition period up until the end of 2020. And during that time, the law remained the same in that European Union law still applied in the UK. And importantly, that meant that the United Kingdom remained part of the European Union trademark and design systems. Now, we are now in March 2021 and Brexit happened fully. The transition period ended at the 1st of January 2021. So we're now in a position where Brexit has happened. We know the outcome and the rules that are in place to handle any fallout from that change insofar as trademarks and designs are concerned. So the next few slides, I'm just going to speak to you about what Brexit means for European Union rights and how they now interact with the UK system. So first of all, two scenarios. And in scenario one, this is the easiest to understand, the easiest from an action perspective as well. So to recap fully, the European Union trademark and design registered rights are unitary in their nature. And what that means is that by simply owning a European Union registered trademark or design, those rights will apply throughout the European Union member states on an equal basis, irrespective of your particular intentions in any of the member state countries. So for example, last year in 2020, if you were to be filing an EU trademark application or a registered community design application, you would be protecting both the UK and the European Union by virtue of the UK's membership of the European Union. But given the UK has left the European Union, is no longer a member state of the Union, that no longer applies, and the UK must be treated as a separate country for all things, and in particular for trademark and design protection. But if you were the owner, or any of your clients were the owners of registered EU rights, be it trademark or design rights, at the end of 2020, there would have been, and there has been, an automatic split of that registration from the 1st of January onwards, whereby your client or you will now own a European Union trademark that protects the 27 other member states of the European Union, but not the UK, and a new, what we've been calling comparable UK trademark registration that some users of the system have referred to as a cloned registration, a new UK registration which is identical to the EU parent, which we've been calling the existing EU mark. That came into force on the 1st of January at no cost, automatically, and that is now an asset separate to the European Union trademark of design that will continue in force. So one right has become two, and there are implications for management and renewal, which I'll explain in a few slides' time. So that's scenario one. Everything that is registered has continued as it was pre-Brexit, but bear in mind there is now a separate new UK registration that has come into being at no cost and will now be on the UK register. The second scenario is where any pending EU applications were in place as of the 31st of December. In this instance, action is required, and the automatic cloning process I referred to previously will not happen for pending applications. And the rules that are in place for those are that by September 30th this year, it will be up to the EU trademark or design proprietor to file a new UK trademark application, again on identical terms to the EU application that's already in place, to ensure that the UK is covered. So if it was the intention that the European Union filing was to cover all of the EU member states, and at the time that would have included the UK, if that desire is to continue, then by the 30th of September this year, a separate new UK application must be filed, and there will be fees payable to the UK Trademark Office for doing so, and that new UK trademark will be examined like any new application that's filed, irrespective of the status of the EU trademark. So now we're in March, some EU trademarks have become registered that were pending as of the 31st of December, but if that application was pending as of the 31st of December, irrespective of whether or not it's registered now, it's that date that is important, and if it was pending as of the 31st December, it will be incumbent upon proprietors to refile in the UK ahead of the September 30 deadline. Otherwise, the UK will not be protected on the same basis as the EU application. And why that's important is if you make the application by the 30 September deadline, if there was any priority claimed in the EU application, say from a US application, then that will carry over to the UK. The UK cloned application, comparable application, would be exactly the same as the EU parent. So there is some incentive to do that before September 30, particularly if it's a priority claim, because if it's filed later than September 30, it will take on a new filing date and obviously not be in tune with the EU application that was filed originally. So here, September 30 is the all-important deadline that requires to be docketed for any pending EU trademark or design applications as of the 31st of December. And as I go through my slide deck, you'll hear that message a few times. So hopefully by the end of the session, September 30, 2021 is a date that you'll have in your mind when you think about your EU trademark application portfolio and any rights that are pending within that. So as I've said, docket that deadline. If there are any pending EU applications, that is the date that must be adhered to get the same rights in the UK. And what we've been doing for our clients is actively monitoring that deadline, speaking to our clients as to whether or not new comparable applications are required. So just to make sure that we're on top of the situation, so there's no loss of rights, and advising clients and keeping in contact with clients on that basis. And what follows from this as well is, as I said, as the UK is no longer a member of the European Union, its trademark system is no longer an option if you want to protect the UK. So in other words, in the future, or from now onwards, from the 1st of January onwards, it will be a requirement for you to file both UK and EU applications to get the same protection as the EU trademark would have given in the past. And we have realised there is some duplication in that, and we have in place a discounted dual filing, sort of combined filing package for identical trademark and design applications at both the UK and European Union IPO. And one other thing on the logistics of what I said previously is, at the last time I checked, which admittedly was before the end of the year, there were around 1.3 million, I think it was, EU trademarks on the register. So there has been a real influx of new cloned UK registrations that came into being as of the 1st of January. And what the UK Trademark Office hasn't done is issue new certificates of registration for each of those new marks or designs that have come on to the register. But what they have done to make it apparent that those marks or designs have come from an EU parent right, if I can call it that, those appear on the register now with the prefix for trademarks of UK 009 and the number 9 for design. So you may have been seeing this already if you've been looking at any portfolios that you have that now have the newly created UK rights in there. And our records have been automatically updated to create those new UK rights in our clients' portfolios. So rest assured that process has been managed for you. The next point, which is quite an interesting point, more so from the way in which you can interact with the UK Trademark Office. So as of December 31, so the start of this year, the UK IPO is no longer going to accept any addresses for service which are in the European Economic Area or in the EU. So previously, it was possible to file a new trademark application, for example, at the UK IPO via a firm of attorneys in, say, Germany. They could file directly at the UK Trademark Office, but by virtue of the rules that are now in place following Brexit, a UK representative or a representative based in Gibraltar or the Channel Islands will be required for any new actions that take place at the UK IPO. So the UK IPO is now really only a forum for action by UK-based representatives, and that would apply to any new filings that take place, any new opposition proceedings, for example, or cancellation actions, or whatever it might be. Those require UK presence, essentially. So one thing to bear in mind, just in terms of the way in which you engage with the UK IPO. One of the questions we've been asked several times now is the UK IPO has seemingly enforced lots of new UK trademark registrations on the proprietors of EU trademarks as of the end of last year. But what if you do not want to benefit from the brand new UK right? The UK IPO has accepted that that's a concern for some, and there is a process whereby you can instruct the UK IPO for your particular trademark or portfolio of EU trademarks to be what is called opted out of that automatic cloning process. So say, for example, you're acting for a client that had an agreement with a third party which said that it was okay for them to own an EU trademark, but they should never acquire a separate UK national trademark registration. Then it might be in that situation that the opt-out request would be made to ensure that agreement isn't breached. And also, if the particular trademark in question is being used in the United Kingdom or is subject to a license here, or there's going to be litigation commencing on behalf of the comparable new cloned UK registration, in those circumstances, the opt-in out process probably isn't going to be an option. But it's good to know that if there are any marks that, say, you already had the UK trademark for, that you filed in tandem with an EU application, if you were going down the dual filing route at the start of last year, for example, then it might be you wouldn't want to go ahead with the cloned mark because there'd be duplication in your UK portfolio. And in that situation, you may wish to opt out. A few points on international trademark registrations filed via the Madrid Protocol. As before, I think a good rule of thumb from now on is to think of the UK and the EU as being completely separate. And for any new Madrid Protocol applications that are filed, or any new filings nationally, then the UK and EU must be covered in their own terms separately. So add the UK to your designation list for international applications and make sure that you're covering the EU as well, just to keep that consistency of approach. And the thing about the new registrations, which is interesting and of note, is that for the comparable new UK rights that have come into place, is that they have not been created as new UK designations. They have been created as separate national UK trademark registrations. So there hasn't been a new UK designation added to your international registrations. There has been a newly created national registration. And the important factor for that mainly is that that UK mark would need its own separate renewal. So that's one thing to bear in mind. And there is, like before, no new certificates that have been issued by the UK IPO. Newly cloned UK registrations from Madrid Protocol have a new prefix of UK 008, and this is the same for any design filings that have been made via the international design filing system. They'll have an 8 as a prefix. And to make it even more complicated, for any subsequently designated EU registrations that may be in your Madrid Protocol portfolios, any of those that have been cloned as national UK rights will have the prefix UK 081, and they will be treated as have been effective from the date on which the EU was subsequently designated. So if you do manage a portfolio of international registrations that have historically always covered the EU only, it's worthwhile looking at this to ensure that you have docketed the new UK registrations that have come into being, and from now on, if you're filing new applications, to make sure that the UK is ticked on the MM2 separate to the EU. Otherwise, protection in the UK will not be achieved. You may act for clients, or you may advise your business on custom notices in the European Union. And in short, that is a mechanism whereby you can lodge at the EU customs authorities essentially an application which says that if any suspect looking products access the EU market that bear a particular trademark, they will be held by customs and the proprietor will be notified, and then you can take action to stop those infringing goods making their way onto the EU market. Previously, and again, this ties into the theme of the UK and EU being now seen as totally separate. Previously, an EU customs notice would cover the whole of the EU plus the UK. It now only covers the EU and no longer applies in the UK. So if you did have those in place, now is the time to apply for a separate UK customs notice, which we call an application for action, to have the same protection continue following the end of the Brexit transition period, and now that the UK has fully left the European Union. Those will need to be recorded separately. And similar to that, going back to EU trademark registration and design registrations, if you have any licenses or security interests recorded against an EU registered right, it will be that those have to be refiled and recorded at the UK IPO before the 1st of January 2022. So that's another deadline for your docket to keep an eye on if you have, or if you can find out from your portfolios, if you have any EU rights that have licenses or security interests registered against them. Those will need to be actioned separately in the UK. And another point on assignments. So if you had, towards the end of 2020, applied to transfer the ownership of rights at the EU IPO, it may be that that process would not have completed in time for the 31st of December cutoff, and it could be that your new UK cloned right will be in the previous owner's name and not the new owner's name, in that the EU proceedings to update the name hadn't completed by the 31st of January, and that automatic cloning that took place will not have reflected the new name. A very sort of niche example, but if you do have any cases that you're aware of where that might apply, you should check the UK comparable marks to make sure that those will be updated to ensure that the marks are in the same owner name and in the correct name. That's just one thing that might slip through the net on timing if you did make any requests towards the end of last year. As you might expect, one of the things which increases burden on EU rights holders is that there has been a whole raft of new UK trademarks that have come into being. So that not only requires a lot of updating to dockets and case management records, but also has an impact on future budgeting for the renewal of those separate and new UK marks. So it is incumbent on the proprietors to ensure that they have docketed the renewal deadline for the new comparable UK rights and take action to ensure that those are renewed in good time. And one of the things that the UK Trademark Office has noticed, or at least appreciated, is that there could be a lot of renewals coming due at the start of this year, for example. And given the sort of duplication of renewal required at both the EU and the UK, they will not be charging any late renewal fees for making renewals between January 1st and July the 1st this year. So if there was some deadlines that were sprung upon you in that period that you hadn't necessarily budgeted for example, there will be the 6-month grace period for renewing late without any additional cost. A slightly technical point, but it's one worth bearing in mind. And there was some attempts to what I would call perhaps game the system, in that, as you may know, you can pay to renew a registration at the EU IPO up to 6 months in advance of its renewal date. So in theory, if there was a renewal that is due today, say, at the EU IPO, that could have been renewed prior to the end of the Brexit transition period, prior to the start of this year. And in theory, that could have had the same effect on the comparable UK trademark rights. So you pay for one renewal at the EU IPO, and that keeps both the EU and the UK trademark registration in force, despite the renewal date being in 2021. However, that isn't the case. And if any renewal dates fell in the calendar year 2021, irrespective of the early renewal that could have been actioned at the EU IPO, those new UK rights must be renewed separately. So that's something that if you thought you had renewed an EU right early and it was off your to-do list, off the budget, then it is worthwhile checking to make sure that there's any, if there are any UK new comparable cloned registrations that require their own renewal in 2021. Otherwise, if you don't renew them, the rights will expire. A couple of slides briefly on any pending proceedings at both the EU and the UK IPOs. So if you have, let's say, a pending opposition at the EU IPO, which was based on a UK trademark registration, which was possible when the UK was in the EU IPO, that case will no longer go ahead to decision. The EU IPO will not be acknowledging any UK rights as of the start of this year. And in actual fact, there are a few cases that I've handled where that was the case, that we had relied on UK rights, and we have already received a decision from the EU IPO that it will not be proceeding to decide the case, and it has been treated as dismissed because we only relied on UK rights. So that is now in effect and has been happening. So check your pending proceedings to make sure there's, well, if there are any that have a UK basis, that you will take the same action in the UK if that EU application is cloned into the UK market. So say you have a pending opposition against an EU trademark that's based on that your opposition is based on a UK right. If that is cloned into the UK, so the same application is cloned into the UK, you would want to find out about that application and file a new opposition in the UK to prevent it proceeding to registration in the UK. Again, slightly technical points, but if you do have any pending proceedings that are in this category, it's certainly worth making sure that you take the same action in the UK. And again, on the flip side to the representation point, at the EU IPO, you must have a representative that's based in the European Union. And as Tania said at the outset, we do have offices across the UK and in Europe. So our service continues as normal and we can handle both UK and EU proceedings. So that is just one thing to bear in mind as well. And any cancellation actions that were successful against an EU trademark registration, those will be honoured by the UK IPO in time. So there's no need to refile a cancellation action in the UK. But as I said, if you have any cases that fall under this umbrella, it's certainly worthwhile having a look to make sure you're doing the right thing to ensure the UK market is getting the same treatment. So on the flip side to that, at the UK IPO, its pending proceedings that were based on EU rights will essentially continue. So if there was an EU registration that was used to oppose an application in the UK, that will simply continue with the new number. And if you were relying on a pending EU application, there will be a 2-month period whereby you can apply to file the application in the UK to have that right come into UK law, and the opposition would continue there. So again, any UK oppositions that were pending that you have in place based on EU earlier rights, do check and make sure that everything is in hand. And needless to say, for these scenarios, if we're handling any cases on your behalf, we will be speaking to you, if we haven't already, about the best way to run these cases going forward. One final slide from me on the differences between the UK trademark and the EU trademark system, because they are quite interesting in their differences, and these are quite impactful, particularly on strategy when it comes to both markets. So I don't think it's the case of thinking about approaching the UK and the EU with the same mindset. There are different things to be aware of. And the first thing really is that in the UK, we have a real desire to see things in two forms. And the first of those is by presentation of arguments. What I've got on the slide here is oral advocacy. We do quite like to have hearings in person, whereby if it is a dispute that both parties attend, present their case in turn to the decision maker, and then the case is decided that way. And as you might appreciate from your experience of the EU IPO, everything is done on paper. So all the arguments that the EU IPO will ever receive tend to be written. So in my personal experience, having the chance to actually present your case orally to someone, and rely on your tools of advocacy to convince someone that you're right and someone else is wrong, that can be quite helpful. And the UK office is quite a useful forum for exploring those types of issues. And the other thing which I mentioned is on evidence. And again, your experience may have made you aware of this, but in the UK, if we're ever presenting evidence to the trademark office, say it is evidence of proof of use and a non-use cancellation action, we will require a witness statement from someone within the business of the trademark proprietor to explain why they've used the trademark, perhaps attach some of the sensitive commercial information like invoices relating to that particular brand to substantiate the case. Whereas at the EU IPO, there's less requirement to have evidence in a more formal form. You can just submit it without a covering statement of truth, which the UK witness statement would have. So really, again, just a slight divergence in approach. Now, on the more sort of technical aspects of it, the opposition deadline in UK trademark system is 2 months extendable to 3 months, whereas in the EU IPO it's 3 months. So just two different deadlines to be mindful of. If you've only had experience really of the EU IPO's practice, then bear in mind that you've got 1 month less at the UK IPO unless you apply to extend that deadline. And in the UK as well, there is a fast track opposition. There's no such fast track at the EU IPO. But the downside to the UK fast track is if your trademark is over 5 years old, you need to file all your evidence of use up front. So although it's a very fast and effective system, it does benefit trademarks that are less than 5 years old. But again, just something to be mindful of. And two final things. The first is that in the UK, a bit like in the US practice, actually, that we do have quite a lot of favour towards user rights, what we call unregistered trademark rights. You may have heard of the common law action or passing off, which is what we often refer to here. That is something that you can rely on if you have lots of use in the UK but no registration. That can be something you can use to stop a new trademark application. Say in the EU, at the EU IPO, that really depends on the local law of the EU member state. So if you've got a lot of use, say in France, it'll be at the mercy of the French law as to whether or not you'll be successful at the EU IPO. And in my experience, that can be quite difficult to make out. And you may be aware of this, but the UK Trademark Office is nowhere near as technically advanced as the EU IPO. So you can't log into a portal on the UK IPO and find the decision or find all the correspondence. A bit like the US PTO, really. You don't get to see into the back of the back office where all the good stuff is held. It is a very limited system at the UK IPO, which often in our experience means that our clients lean on us a bit more at the UK IPO to find out about particular files, what happened in an examination in a particular case, whereas at the EU IPO you can find all of that stuff quite readily available if you have a user ID at the office. So with that, I'm going to hand you back to Tania, who will talk to you about the mechanics of handling UK trademark applications.
Thank you, Mark. So yes, I'm just going to talk you through the UK trademark application forms. Insofar as a country of incorporation, we would also need to include the state in the US. And we have what we call a series mark application possibility in the UK. A series is basically a series of, for example, logos or the marks. It could be in different colours. They have to be essentially very, very similar. The differences must be minor. And there's a maximum of 6 trademarks within one series. The advantage is that they're all included within that one trademark application, and you pay an extra official fee of £50 for the 3rd, 4th, 5th and 6th. So you don't pay for the first 2. So if you've got a logo in 2 colours, you may as well file it in both in the UK. And as Mark was talking about these comparable applications, there's been a tendency to call them cloned. That's the other word we tend to use. But on the form, we have to give in details if we're going to be filing a UK comparable application to benefit from it being backdated to the EU application or the EU designation, which was pending as of the end of last year. And then separately to that, if we're claiming priority, then we would actually put the priority details in as well. And then subsequently, as I said, the full details of the earlier EU IPO application or the EU designation. The other kind of quirky thing about the UK is that you do have to state on behalf of the applicant that it has a bona fide intention to use the trademark, which is something which doesn't exist in the EU system, but they have to show, and in fact it's something based on which you could actually contest the application if somebody was filing in a completely different area and it was quite obvious they didn't have a bona fide or honest intention to use the mark. And now Simone is going to go over the EU trademark application form.
Thank you, Tania. Yeah, here on the right-hand side, you can see part of the online filing form. of a European trademark application. And if you want to claim priority of an earlier application, in this example, the United States, you can do that on filing, and you also have to add your date of the earlier filing. You also have to provide a priority certificate, and you can submit it when filing the application within a deadline of 3 months. And for European trademark applications, you have to select 2 languages. The first language is for correspondence, and it's usually in English. And the second language is for possible opposition matters. And as I'm based in the Munich office, would usually go for German. There are 3 kinds of trademarks. There's an individual mark, a collective mark, and a certification mark. For your individual mark, you have your usual word mark or figurative mark. And if you want to protect a 3-dimensional shape, you can do that with a shape mark. You can see some examples on the bottom. Here you can see some further trademark types. You can apply for a motion mark or a sound mark. You can request for a national search report. So if you want to have a search report from a European country like Germany, you can request for that, and you have to pay an additional fee, but this is optional. And you can also request for a European search report, and this is free of charge and also optional. Now I'm going to head back to Tania.
Thank you, Simone. So yes, I'm going to be talking about designs now. I'm obviously going to just give you the UK aspect, and then Simone is going to speak to you about the EU designs. So there are some fundamental differences between them. Insofar as disclaimers are concerned, these are not available in the EU, but they are available in the UK. So you can limit down your design protection to particular features or aspects to actually disclaim those. And also the great advantage of the UK is that you can actually file applications, multiple applications for designs across different Locarno classes, whereas in the EU they have to all be within the same Locarno class. This is probably something which is slightly unusual for you in the US, in that we can basically put a number of designs, any number of designs within one application, so it makes it a lot more cost effective. Also, you can defer publication. It's much more restricted in the UK, it's only for 12 months, whereas in the EU you can defer publication for up to 30 months. The renewal fees in the UK are on the anniversary of the registration date, which is something we're used to doing, obviously, with trademarks, whereas in the EU, the renewal fees are due at the end of the calendar month in which the anniversary falls. And there's a 6 months grace period, both in the UK and in the EU. The other difference is that the UK allows up to 12 representations, so it's quite generous. With the EU, it's only 7, so you might have to narrow it down. Representations, the different ways in which you want to present the design. And with the UK, you actually get a different number with each design. So even though you've done one multiple design application with, for example, 10, 20 designs within one application, you'll get a different number for each. That's not the case in the EU. And if you want immediate publication, then you don't pay a publication fee, but if you want to defer it, then you do. And as I said, the 12 months deferral from the filing date. It normally, I'm saying normally, pre-Brexit, would take about 2 weeks to get your registration certificate, because it's only examined on the basis of formalities in the UK. At the moment, I've just heard from the UK IPO, it's taking about 8 weeks. Because of the huge influx, as you can imagine, with doubling up of filing. So it's taking a lot longer, unfortunately. You can so put in a description, that's completely optional, but a title is required. So you do have to actually restrict it to a title. And then this is an example of a disclaimer using visual or written disclaimers. If a visual disclaimer is used, it's usually better to also have a corresponding statement. And there's an example of some of the representations that you can include. And insofar as how you file it, you can file it in JPEG, GIF or TIFF format. You can include photographs. It's very, UK and EU is very flexible as a system with designs. You can also go down the route of line drawings, CAD images, color, broken lines, 3D models. And the advantage basically of the multiple design is that you could obviously do a multiple design application with several different representations. So you could have line drawings as one design, and then you could have photographs as another design, all within the same application, which gives you a much, much broader protection if you're going to have to litigate on the basis of that design registration. Just be slightly warned that the representations, especially if you actually file them based on drawings, they can look a bit faint, but they will be clearer when actually viewed on the register. And we tend to generally advise against any heavy US style shading. So insofar as the representations are concerned, here's a good example of two different formats being used, which would mean that effectively this has to be a multiple design application for two designs. It's not one design because they're two different types of formats. And now I'm going to hand you back to Simone, who's going to talk to you about EU.
Thank you. Yeah, the number of designs in a multiple application is unlimited for European designs. You can have 7 views per design. You can add more views, but they will not be protected. For your Locarno classification, you can either search or browse for it, or you can enter your own terms. It is possible to request that your application, that the publication of the application is delayed for a period up to 30 months. And yeah, your design will be kept confidential. It is possible to add a description, and this is mandatory and is not examined, and the description can contain a maximum of 100 words. Here you can add the designer information, and the designer has also the right to waive his right to be cited in the register. If you want to claim priority from an early application, you can add it when filing the application or within a deadline of 1 month. If you have displayed your design on an exhibition, you can claim a so-called exhibition priority, and you can do that when filing the application or also within a deadline of 1 month. And you have to select the name and the date of the exhibition, and also provide exhibition documents for the evidence as of the display. And you can submit it when filing the application or within a deadline of 3 months. I'm gonna head back to Mark now.
Thank you, Simone. And with that, I'm going to conclude with a few points just to reiterate what we have advised and consolidate some of the points that we've raised. So firstly, I hope that you've found that beneficial. I have noticed there's some questions coming in, so I would encourage any more if you have anything you'd like us to consider, just to add them to the chat box, or at the end if you feel free to unmute yourself and ask. But just to conclude, and I purposely thought that it'd be quite helpful just to have some practical guidance on this, because there is a lot of content, there's a lot of detail, particularly on Brexit, that you know, might apply to a certain number of cases, but there are some real headlines that you can take away and start working on now if you haven't already. And the first of those, which isn't actually a Brexit related point, is that in the UK and EU practice, we do tend to see shapes as being both assets that can be protected as designs and trademarks. So we're often asked to advise on that, and we often find ourselves protecting shapes as both designs and trademarks. So that's just something to bear in mind if you are considering making any new applications in the UK or Europe on or for shapes, that you think about both trademarks and designs. There are pros and cons to both, of course, but having both rights registered gives you the best protection in the grand scheme of things. And as I've said already, and this is really probably the highlight, is that you need to now be thinking about filing two separate applications, what we've been calling dual filing, in the EU and the UK to get the same types of protection that you were looking for before Brexit occurred. So that can be either separate national filings at the UK IPO and the EU IPO, which we can help you with as a European firm. And also, if you're filing Madrid Protocol applications, for example, you will want to include the UK and the EU separately. And if you handle a renewal portfolio, bear in mind that all these new UK cloned comparable registrations, both trademarks and designs, will need to be docketed, monitored, and renewal fees will need to be paid to keep those in force. And that also applies to the existing EU rights that are unaffected, in the sense that they will continue to protect those particular rights in the other member states of the EU, but just not the UK. So think of them now as separate. And as I said earlier, I think it's worthwhile reviewing any new comparable trademark applications that will come into being if you had any oppositions proceeding against the parent EU trademark that are ongoing presently or may have just recently concluded, just to ensure that you're having the same levels of protection or taking the same action in the UK as well. And that also applies to any cases that you are defending an opposition on. If you take a decision to then file a comparable UK application, you might expect potentially to have the same opponent rely on their new UK rights or previous existing UK rights to try and stop that mark going ahead. So there's some strategy around that particular set of circumstances that should be considered. And on deadlines, which again, as attorneys in the IP space, we are obsessed with, the deadline that you really need to be thinking about now is the September 30 comparable refiling deadline for any pending applications at the EU IPO as of the end of 2020. And that applies to any pending designations under the Madrid Protocol as well, for EU designations, that is. So if you have got a large portfolio of EU trademarks that didn't quite get registered before the end of the year, then you need to be mindful of the fact that you should file applications in the UK before September 30. And as Tania touched upon, the UK IPO has seen a real increase in volume of filings of late, and its process is a lot slower than it used to be, which admittedly was extremely quick. It's now just quick as opposed to extremely quick, but just something to bear in mind. If you've got a number of marks to be filed, that there might be a slight delay in getting them through to registration, but I think that might continue towards that deadline anyway. But I think probably there might be an influx at the start of the year just to get a number of pending cases filed ASAP to get the registration certificate in the UK quicker. On the other deadline, January 1 next year, 2020, as I said, any license and recordals at the EU IPO, those should be mirrored in the UK, and that will take some action, and not driven by deadlines, but just something to be mindful of. The point I made earlier about any request to change ownership, and that could also apply to change of name and address as well. If they were filed towards the end of the year, typically the EU Trademark Office would process those within about 4 weeks. So if you filed one in December, it may have not got across the line, and your registration would have come into UK law with the old name, the old address, the old owner. So you will need to update that at the UK IPO separately. And I think the other point, which I made at the start, which I should probably make again, is that if you also handle any patents, that the European patent is unaffected by Brexit. It's not an instrument of the European Union like the EU IPO and the EU trademark and design rights are. It's not the European Union patent, it's the European patent. So there's a slight difference, but a very important difference, that none of what we said applies to any patent applications that may be outstanding, for example. And a final point, again, this is sort of going over the ground and reiterating what I said before, but we as a firm are European. We have offices in the UK, in France, and in Germany. We can handle cases at both the UK IPO and the EU IPO. And as we've been saying for a while, it's business as usual with us. So rest assured that anything that you've entrusted to us will continue as it is at both the UK IPO and EU IPO. So there's nothing to be changed, and nothing to worry about there. That will continue as it is, which is reassuring. If you do have any questions that you want to ask afterwards, our contact details are in the slide deck, which we will share with you. There have been some questions that have come into the chat box, and I think what I'll do now is hand back to Tania to moderate those, and we can answer those and give you some more guidance.
Thank you, Mark. Thank you, Simone. So